Chair calls Ashley Leenerts.
Thank you, Chairman Dutton and members of the committee. And my name is Ashley Leenerts, and I serve as a legislative associate for Texas Right to Life. And I'm here to testify in favor of House Bill 1734 by Representative Leach. This is the first session since Roe has been overturned. The legislature has a unique opportunity to show that our state is not just anti-abortion, but truly pro-life. And House Bill 1734 is a great example of this. The mother's financial responsibilities begin immediately upon finding out she is pregnant, but the fathers currently do not until the child is born. This includes healthcare expenses, of course, but it also includes other expenses that begin to be incurred upon pregnancy and preparation for the baby's arrival. Texas Right to Life supports the goal of this bill to extend retroactive child support to the earliest possible date of the child's conception as determined by a physician. We support this bill that would also order the father to pay an equitable portion of the prenatal and postnatal care expenses, both for the mother and the preborn child. This bill would also allow proceedings to begin before the birth of the child if the pregnant mother commences them, and the bill would also allow the ordering of in utero genetic testing to confirm the parenthood of the father if the pregnant mother makes this request and a physician determines that there is no danger in these requests being made to both the mother and the unborn child. This legislation highlights the preborn of the human child and is an important role, and it shows the important role of fathers in their children's lives. It also recognizes the important time frame of pregnancy for children, both in the healthcare and financial responsibilities that fathers have and mothers have to their child. These common sense measures would continue to allow our state to build a pro-life Texas, but also provide that mothers and children are both welcome in our state and able to succeed here. We look forward to a favorable consideration of House Bill 1734, and I'm happy to answer any questions.
All right. Thank you, Ms. Leenerts.
Thank you.
Are there any questions, members? Not hearing any. Thank you for your testimony.
Yes,
Chair calls Arnold Yan. Chair calls Dr. Joe Pojman.
Mr. Chairman, members, my name is Dr. Joe Pojman. I'm Executive Director of Texas Alliance for Life. We strongly support this bill, House Bill 1734, and we thank Chair Leach for authoring it. It has been the policy of this state to recognize the personhood of the unborn child for decades. Since 2003, if a pregnant woman is assaulted and the unborn child dies as a result of that assault, as a result of that offense, it's recognized as a crime of homicide of the unborn child. That protection for the unborn child begins at the child's conception. This bill would protect the mother and the unborn child with respect to paternity, especially the cost of pregnancy and childbirth. It would begin to correct the injustice that has existed for decades, and that's why we support it.
All right. All right. Thank you, Doctor. Let me ask you a question, though. If, and I think one of the witnesses alluded to this earlier, if the mother engages in certain behavior that results in the cost of medical care for some reason being different than it would have been ordinarily, does that factor into this, or should that factor into it?
I'm not really sure, but I think there's a discretion of the court to award the costs. So presumably the judge could take that into account.
Well, then that raises a question, too. Maybe I'll ask Chairman Leach, but, I mean, does this become sort of an increased cost? Because now one expert, I assume, is going to talk about the medical cost, and the other side's going to have an expert to take a look at that and determine whether, and of course, I see it says reasonable, but I don't know if that means it's going to be reasonable and necessary. And whether or not you're going to now have the battle of the experts trying to decide, first of all, when conception exists. Secondly, whether or not the medical care that was provided was in total necessary.
That's a very good question. I think the bill does address the question of conception, and it's the earliest possible time of conception, because you have to define at some place We're not necessarily sure exactly when that happens.
Right.
With regard to the other costs, again, maybe Mr. Chairman Leach could answer that. I confess I'm not sure what his intent is.
All right, okay. All right, thanks. Any other questions, members? All right. Yeah. Chair at this time calls Steve Bresnen.
Thank you, Mr. Chairman. I'm Steve Bresnen. I'm here on my own behalf. It's a rarity here. Sometimes I get asked to talk about things where I don't have a client I'm representing. It's unusual for me to testify on something on my own behalf, but just because I register with the Ethics Commission doesn't mean I don't have the same rights as any other American. I appreciate you very much for bringing this bill, which I fully support. And in particular, I want to emphasize the prenatal and postnatal health care cost. Mr. Chairman, was there a substitute laid out, or am I on the bill as filed?
There is a substitute laid out.
Okay, I'm going to refer to the substitute. I think the answer, and I'm going to make a suggestion to Chairman Leach and the committee. In the substitute, on line, as I've printed it out, line 132, it's in subsection H of the bill. It calls for an equitable portion of prenatal and postnatal expenses. This is not an open checkbook for anybody. And certainly, a woman's conduct before or during pregnancy that might have affected those costs could certainly be included in the calculation of what was equitable. If her insurance covered the cost, that could figure into whether it was equitable. Or if somebody else, if her family paid the cost, the court could figure that. The court could even figure, determine equity. She may be a moneyed person who could afford those things, and the man may not be able to afford anything or may be able to afford less. I started using the term carrying costs for this, that the woman experiences the carrying costs. This has gone on since the beginning of time with no a foolproof way to get compensation. So while I was sitting there, I looked up the term carrying cost because I knew it from business when I was in retailing. And it's the amount that a business spends on holding inventory over a period of time. I don't want to refer to children as inventory, but these are expenses incurred by a woman in the time she's holding the child and then shortly after giving birth. My suggestion, Mr. Chairman, there's an ambiguity in my opinion, in the substitute. In the new subsection G that's in section 2, it says the court shall, on request of a party and a proper showing, order retroactive support as in 151, 131. And when you go back to that, it says may award an equitable portion of prenatal and postnatal health care expenses. I think that should be cleared up, and it should be mandatory. If anything should be mandatory, the woman's carrying costs for that pregnancy ought to be able to be reimbursed on an equitable basis. We don't agree on a lot of things. If you follow my Twitter, I don't like where we are after Dobbs. I don't think you'll doubt that in any way. But we can damn sure agree that if women are going to be having kids forced to term by state policy, then by God, they ought to be reimbursed for their prenatal and postnatal health care expenses related to that on an equitable basis.
Let me ask you a question, though, Steve.
Yes, sir.
You talked about the woman incurring the cost. You know, we have a philosophy in law that requires it not to only be incurred but paid.
Yes, sir.
And does that apply? But should that apply here also?
I think that if the short answer is, if you drag me into a paid or incurred and make me put my trial lawyer representative hat on, I'm going to be very unhappy about that. So, but let me answer you this way. Equity has been established for centuries in the law of this country and the country it came from. So courts can do equity by considering all of these considerations. They're thoughtful considerations that y'all have brought up, very thoughtful. But the word equity can do a lot. And that's why that line and that word is so important. But direct the courts to do equity. Don't just leave it up to them to do it or not do it, please.
Okay. All right. Any questions? I think Representative Cook has a question.
Under current law, do you think a state district judge has the authority to order prenatal expenses?
There's a May in 154, 131 currently.
Thank you.
Okay. Any further questions, members? All right. Steve, thank you for being
Thank you
here.
very
Thank you
much.
for your testimony.
Appreciate y'all.